All right, good morning, Miss Lee. Ma'am, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. On June 16th, 2023, a law enforcement officer conducted an investigation and made contact with the complaining witness. The complaining witness stated she was in the leasing office at an apartment complex when the defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office.
Okay, pause for a second. This is where things get complicated. The judge is issuing a trespass warning. But here's the catch: if Miss Lee actually lives in that apartment complex, can you really trespass someone from their own home? That's the legal tension here, and it's why this case is far from straightforward.
The law enforcement officer issued a written criminal trespass on June 2nd, 2023. The defendant stated she understood the criminal trespass warning at the time. The law enforcement officer attempted to make contact with the defendant, who refused to answer the front door, but yelled she was not going to open the door unless the law enforcement officer had a warrant. The defendant was identified by her.
Does she live there?
Yes.
I do not have any facts that demonstrate that in the officer's sworn statement.
Okay, so let's do this. Miss Lee, I'll appoint you a lawyer today so we can get to the bottom of it, and then I can make a ruling a little bit later. What I'll have you do is I'll just have you sign a receipt with Victoria. We'll have you take a seat. Let me appoint you a lawyer, and then we'll have them investigate a little bit further, okay? Please.
Right this way.
Judge, can you sign bond petitions on Dominique?
Yeah.
Approaching on Simone Lee, because you'd expressed some questions about probable cause in her case,
Correct.
as I have myself.
Okay.
So this is her leasing office. She needs to go in there to access her mailbox, to access, various things. The time that she went in and received a so-called trespass warning, which when her car was broken in and she was expressing concerns about it.
My only issue is that a lot of people say it, but they're really not on it. So if you show me that she has like a lease with her name on it at that complex, that would make a huge difference.
She left, but they even say it in the report. There's no dispute on the fact that she lives in there. She was in that leasing office because her car had been broken in. She has text on her phone right now after they gave her the trespass warning for her just trying to sit there while the police come. She would contact them and get authorization from them saying you can come in, just for her to check her own mailbox. So she has text right now on her phone that could show you she lived there, her contact between her and the office.
But I think at this particular moment, I mean, she goes in allegedly huffing and puffing. So they say, hey, get out. Right? And can you read me the DIMS again? State, please.
Yes, sir.
Only.
Looks like on June 16th, 2023, the officer conducted an investigation, made contact with the complaining witness. The complaining witness stated she was in the leasing office of the apartment complex when the defendant entered after she was given a criminal trespass warning. The defendant was yelling during business hours while the complaining witness had future residents in the lobby and office. The law enforcement officer issued a written criminal trespass on June 2nd, 2023.
So we know that from June, there's a trespass warning that she can't go. Are you telling me after that she has a text from the leasing office saying that she can't go?
Correct. This is where her mailbox says she has to go in.
Whoa, did you catch that? Even the judge admits he'd be huffing and puffing too if his air conditioner broke in the Texas heat. This is where the human side of the courtroom shows judges balancing empathy with the letter of the law. Quick question: do you think Miss Lee should have been trespassed at all if she actually lives there? Or was the leasing office just overreacting?
Your Honor, from the bench report, it looks like the defendant came in and caused the disturbance, saying because her air conditioner was not working.
I'd be huffing and puffing too.
Yes, Your Honor.
And there it is, the judge sets a formal hearing for Monday. Translation: he is not ready to rule yet, because the key evidence is missing the lease agreement and those text messages. That's huge. Without them, the whole case rests on shaky ground. This is the cliffhanger. Will the documents prove she had the right to be there, or seal her fate?
Apparently, the leasing office sent maintenance personnel to the defendant's apartment to fix the issue, but she refused to allow them inside the apartment.
Well, I don't know. So let's do this. Today's Friday. Let's set it for Monday for a formal hearing. See if you can get some kind of lease, because I'd like to know
Okay.
if she does,
You want me to
like
come back?
named lease.
Name,
Yeah,
please, and copies of the text messages?
sure.
Okay.
And then let's set it for formal probable cause hearing, because I don't know how you can possibly trespass someone where they live, and then you give them authority, hey, come back. Right? You know?
Yes, Your Honor.
So we'll set it for Monday for a formal probable cause hearing. In the interim, I'm going to order her not to go over there. Come up, Miss Lee,
She's,
until we figure this out. Say that again?
she does not live there anymore, but yeah.
It's probably a good idea.
Mhm.
Okay, we're going to set this for a formal probable cause hearing for Monday. Don't go back to this place. Don't have contact with the complaining witness in this case. It's not going to go well if you do. Just don't, and then all will be fine, okay? They're going to create those bond conditions. We'll have you sign it, and then after that, you'll be free to go, and we'll resume back on Monday, okay?
Okay, Rick. Thank
Okay.
you, Judge.
Thanks. But don't leave until you sign those bond conditions, man. Okay. You are Luis Garcia.
Yes, sir.
Mr. Garcia, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On March 30th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a welfare check on a vehicle and found the vehicle clearly stopped on the right-hand shoulder. On contact with the defendant, the law enforcement officer observed red, glossy eyes and the odor of alcoholic beverage. Defendant admitted to consuming 10 beers at a bar before operating his vehicle. On the Friday test, the law enforcement officer witnessed 6 out of 6 clues in the HDN, 5 out of 8 on the walking to, and 3 out of 4 on one leg stand. Defendant consented to a breath test and blew, I believe this to be an error in the Judge, Your Honor, but it says 0.016 and 0.0156. I believe it to mean.
Wait, it should be one.
Yes, Your Honor.
I don't know. I mean, you can look in the OR, I guess, just to see. Regardless, I think there's enough to go forward. Mr. Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? And does he have any priority to be honest?
Yes, Your Honor. No priority to this, and he is eligible.
Thanks. Mr. Garcia, like I said, I'm finding probable cause. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you to see. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir?
I have one already. I'll hire one. I think she was on Zoom. She was on the Zoom, Romero Associates.
Rodriguez, Carlos.
Oh, Carlos. Ms. Broholm, are you here for a case?
Judge, I'm here for the non-disclosure. It's in your queue. I approached you on it on Monday. You said you granted, but we had a filing issue, so I refiled it.
Okay, I'll sign it. But okay.
Thank you, Judge.
Yep. Okay, so I guess let's do this. I'm gonna have you sign a reset. I'll have you get with Fleischer for your bond condition, then we'll just have you wait for your lawyer to get here, okay? Don't leave until they get here, though, please. You're Noel Garcia Castillo. Sir, you're charged with driving while intoxicated. Second offense. Looks like they're going to reduce it to a first. However, it's still above a 0.15. So you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail to be probated for 15 months. As part of this agreement, you will do a repeat offender DWI education class. You will do 2 victim impact panels. You will do, has he done a TRAS yet?
No, sir.
You will do a TRAS. This is an evaluation to see what other conditions you may need. You must fulfill any conditions that they state that you need to do. It could be intensive outpatient, it could be supportive out, whatever it is, you must fulfill those conditions. You must do substance abuse treatment, no drugs, no alcohol. You must have a guardian interlock and perform 20 hours of community service.
Soto?
Do you have children?
Yes.
I would rather do a parenting class instead of this stupid community service that just, you don't learn anything. If that's okay, guys, you know? You must also have restitution in the amount of $1,000. Is it true or untrue that you had a 0.15 or above, sir?
Aliento o más alto, ¿es verdad? True, true.
You know, from now on, whenever you get pulled over, officers, they're going to see two DWIs. What do you think they're going to do to you if they come to you and they smell alcohol?
You're gonna arrest me.
What happens next time?
Va a pasar al próximo arresto. Go to jail?
No,
No.
prison.
Penitencia.
You're looking at a minimum of
Lo
2 years
mínimo
in
de
prison, a
2 años
maximum
en la
of 10
penitencia, lo máximo
years
hasta
in
10
prison.
años en
Now,
la
we
penitencia.
have to get a hold of you so that you realize that this is not a joke and that you should take this seriously. As part of this agreement, you will be required to pay the DPS fines and fees. And if you don't, every day or every $100 that you owe, you will sit 1 day in jail. Do you understand? Somehow we have to get a hold of you that you understand that this is not a joke.
Esto no es un
Your
juego.
lawyer has worked in agreements that you're foregoing any jail time when there is a minimum of 5 days in jail because of the reduction. You now will be required to pay somewhere in the neighborhood of around $5,000 to $5,500. And if you don't, every $100 you owe,
No lo
1
hace.
day in jail. Do you understand?
¿Usted lo entiende? Yes.
About 100 and then whatever the fines are, you'll be required to pay. But first, I want restitution paid
Okay.
off the bat. He's got to pay the restitution first. And then after that, he can start paying the fees.
Judge, I did file a to waive DPS.
I'm not going to waive it.
No le
No,
voy a
he's not
quitar el
indigent.
resto, dice,
No.
no,
And
no le voy a quitar ese
he's already skirting the
Okay.
mandatory jail time as it is. So somehow we have to get a hold of you so that you see that we mean business. And I hope that this is it before
Pero no,
someone either dies or before you graduate to felony status. There is no breath test refusal as well.
sí,
If you were pulled over in a car, an officer asks you to submit a breath test, you must do it. If you fail to, then you're in violation of this probation. This is only while you're on probation for this case. Does he have a license to drive?
He does not. He hasn't been
Dice,
driving.
no ha estado
Don't have a license. The worst possible thing you can do in this short life that we have is get into a car and drive. If I find that you do, I don't care what your excuse is, you're looking at an entire year in jail. Do you understand?
Totalmente un año de
How do you
encarcelado.
plead to this offense,
¿Cómo que
guilty or
declaras
not
la
guilty?
ofensa? Culpable, no.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal.
Renuncias a una-
Once you accept this agreement, it's done and over forever. You can never come back and change this. You understand?
¿Entiende?
Is this what you want to do?
¿Es lo que usted decía hacer?
All right.
Yes, sir.
All right, sir. I'm going to find you guilty.
¿Y lo culpable?
So I'm ordering the 20 hours of community service. If he does a parenting class, I'll consider it waived in lieu of. All right, good luck to you, sir. Thanks, Frank.
Thank you, Judge.
Reckless driving, Judge, do you want him up?
No. I had a bit of an issue with this. So that's why I wanted to appoint him someone to see. Go to the left. Out of view. There we go. Okay, perfect. Okay, so can you read me the DIMS again, Alex? please?
Yes, Your Honor. So on March 27th, 2025 in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 88 miles per hour in a 50-mile-per-hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed on the video.
So
Even
well, let's break it.
Complaint, it basically alleges unsafe lane change. It doesn't really.
Is that the basis for the reckless driving, the unsafe lane change?
So the way that the charging instrument reads is essentially, in word for word, is reckless to drive a vehicle in willful and wanton disregard for safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was the defendant coming out of the parking lot onto the feeder road. He does cut across 3 lanes to go to the far lane. but I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
Coronado?
That's,
I'm gonna admonish you.
I think that's fair, Your Honor.
Come up. Who is it again? Do you watch the news?
Yes, sir.
Do you really? Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day, not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. You know, yours is not the worst, and I'm going to find no probable cause. But be safe. You know, we're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people, how can you help me? Because I have someone that's suing me for $50,000 because I got into an accident and crashed and I broke their car. They literally ask me to represent them and help them because they don't know where to go to, where to turn because someone filed a lawsuit against them. If someone does that and you get a judgment against you, you're hosed. Get car insurance, and when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much, all right?
We had a conversation about that already, Judge.
Be safe. It's not much. You know, if you got to get somewhere in a hurry, leave earlier, all right? All right, I'm going to find no probable cause in your case, all right? Take care, man. Be safe. If I see you back, it's not going to go. All right, please.
Thank you, Your Honor.
Thank you.
Alamos, first setting.
Okay, do you mind bringing him up?
Yes, Mario, come on up, please. Full waive probable cause, Judge. It's changing lanes with other vehicles present.
I'd like to step here.
Okay.
Good morning, Mr. Alamos.
Good morning.
Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 29, 2025, in Harris County, Texas, a law enforcement officer witnessed a vehicle fail to maintain a single lane by struggling across lane lines with other vehicles having to floor the vehicle and then failed to signal a lane change. Law enforcement officer conducted a traffic stop and made contact with the defendant. The law enforcement officer observed the defendant to have a strong odor of alcoholic beverage. Also observed there to be mouthwash in the vehicle and 2 beers on the floor. It's not safe if those were open or not.
Cold to the touch.
I do not believe it says that either, Your Honor. It just says 2 Modelo beer cans on the passenger floorboard.
Okay.
As far as the defendant admitted to drinking multiple alcoholic beverages, SMSDs were conducted where the law enforcement officer went to 6 out of 6 on the HGN, 2 on the 1 leg stand. The defendant was unable to complete the walk return. The modified wrong burger was also completed where the defendant had a slight sway and estimated the passing of 30 seconds and 13 seconds. The defendant considered to a breath test at 0.086 and 0.084.
Mr. Alamos, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm also now placing a further restriction. You're not allowed to drive any vehicle that doesn't have an interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand?
Judge, may I answer your question? It's first CWI. It's point
He has a
zero.
prior DWI.
No,
He was dismissed. I see it.
That prior-
And now he's got alcohol in the car.
Just for the court's information, the reason why it was dismissed is because he blew a .05. They had no reason to arrest him in the first place, and he can verify that.
Remember that they don't need breath tests to prove, there's just an aid to convict, just like breath tests, just like field sobriety test. Back in the day, no one had anything, right?
Mhm.
So regardless, I want to know for the time being that you don't have any issues. Do you understand, or would you like me to get a translator?
No lo entiendo bien.
Okay.
Te voy a poner una máquina en tu auto. Tú no puedes manejar si no tienes una máquina en el auto. No puedes tomar alcohol, usar drogas y te voy a poner en exámenes para ver si estás tomando. Si tú tomas, si manejes sin esa máquina, te pongo en la cárcel. ¿Me entiendes? All right. Yo quiero saber que tú no tienes un problema y que no vas a matar a una persona en el calle. Right. If time passes and we're good after some time, come back and we
Like
can
after-
talk.
okay,
But
sounds
for the
good.
time being, I want to know that we don't have a problem.
That's fair, Judge. So maybe 60 days or what do you think, 90?
Tú tienes abogado, porque tú tienes abogado, no tienes que regresar a la corte hasta que ellos te dicen. Pero si ellos me dicen que no pueden contactar y no estás comunicando, voy a revocar la fianza. ¿Entiendes? All right? Okay.
Judge, I don't think we had an eligible license on him.
Oh, we do not, Your Honor. I don't have a driver's license to run, but I don't.
You need a license.
¿Tienes una licencia para manejar?
Sí,
De Texas.
sí.
Yeah, he's been in the United States since 1990,
Um,
1980s, Judge. I
Do you
mean,
mind? Can we verify?
sure. ¿Cuál es tu licencia?
Yeah. Just, are you able to do it, please?
No, we,
I can run it, Your Honor.
All right. Solamente quiero saber si tú tienes un válido y puedes manejar.
Judge, it's a,
Well, don't do it here because
Yeah.
live streaming, so I don't want the entire world to see it.
no, it expires 2020.
Okay, we're good. All right.
I'll look at it.